Should there be some provisions in the law for those who make a mockery of our electoral system?
If it is a candidate, whether elected or not, that willfully participated in this, I think the solution should be in a court of law.
For all the people who think this is a joke, are you laughing now? Our elections are not a laughing matter, especially for Canadians who already face challenges voting. Yet during committee, Thomas Shukevich treated the process like a joke, laughing at MPs, the chair, and by extension, the voters themselves. But when witnesses at committee start saying that long ballot candidates should be dealt with in court, I don't think that laughter is going to last very long. Let's take a look.
Not only is the long ballot initiative unjustified, in my view, it is also exceedingly disruptive to the act of voting, with very important consequences to which I shall allude. Elections are the process whereby the very legitimacy of Parliament, the very legitimacy of the members of Parliament, of which you are, is established. That's how we establish how we govern ourselves, and we must do it not only legally, but with legitimacy. In Canada, there is only one definition of an elector, and everyone has the right to vote except the chief electoral officer in a federal election. From coast to coast to coast, there's only one definition. Every elector faces the same process when there's a general election, when they appear to vote in person. They also face the same process if they vote by at advance polls or by mail-in ballot. It is the same procedure for everyone in the same circumstance. The long ballot initiative vitiates that fundamental rule.
Off to the race we go. So, ladies and gentlemen, just to recap, this is the Standing Committee for Procedure and House Affairs, or as it's most commonly known as PROC. And they're continuing their study on the longest ballot committee. Now, this gentleman in question is Jean-Pierre Kingsley. He was the Chief Electoral Officer for Elections Canada from 1990 until 2007. So he was the Chief Electoral Officer during Liberal and Conservative governments. No doubt that's why they asked him to come, because he's seen both sides. And this is a seasoned veteran Chief Electoral Officer, has seen a lot of things, and he's giving his opinion. He's saying that, listen, the election itself establishes the legitimacy of Parliament, of the government. If people start making a mockery of that election, then it undermines the legitimacy of Parliament itself, and therefore government. And there's only one definition for an elector, and it's the same for everybody. They participate in the process the same. That's the whole point of it. And the longest ballot is undermining that process. So he's painting a very serious picture of what they're actually doing. And it is serious. We've been calling it out, and we're glad that parliamentarians are calling it out. Not so glad that most of the Liberals are not calling it out. The only Liberal that was calling it out was removed from the committee, so what does that say about how serious the Liberals are taking this? But this is serious, and it needs to be dealt with seriously.
I'm sure you've been watching the testimony here. I've advocated several different things. First of all, I thought the government of the day made a mistake in 2017 by not appealing the decision out of the Alberta court that removed the $1,000 bond. If I could just quickly get your thoughts on whether or not, given the shenanigans that have happened since that bond has been removed, do you think that there is enough of a case that could be made to reinstate that bond?
I would hesitate to do $1,000, sir.
Okay.
If it has to be reinstated, it could be somewhere in the hundreds, lower hundreds.
Okay.
To act as a kind of a natural barrier, but $1,000 becomes substantial.
Okay. Well, that was the argument that was made to remove by Mr. Shushkevich, Kieran Shushkevich, at the court. and he actually said that he made the case that it's there to protect the election from the integrity of the election from frivolous candidates. I would suggest to you that this is an orchestrated campaign by the longest ballot committee, which appears to be operating in the entirety of a structure of a political party. It's got central, we've heard witnesses here say that it's got central communications. It knows how to play the game. It knows what it's doing, and they're running multiple candidates in one riding. And while you might have mentioned several of the by-elections, they're also doing this during the general election as well. So if we're not going to have the bond, and if you think the bond is not there, what's the number for the number of signatures then? Because I would suggest to you that if it's 100, the government of the day in the last parliament suggested dropping that down to 75. How many is required? How many is sufficient? Is it 250? Because in some places like Nunavut or places where there's a lot of small, remote, rural communities, it might be difficult to get those signatures in an amount of time. So is that the solution?
Well, in my view, the solution would be somewhere along the lines of what I recommended. You can only sign once. And in terms of numbers, I thought the number of 100 did not create a problem in most ridings, and in the rural ones, it's 50 that is required.
That's right.
Yeah.
But now if you've got 200 candidates, each with 50 signatures, and we've heard the current electoral officer say that it's hard to even find employees to work elections, how many more staff and how many more resources would it take to cross-reference 200 candidates at 50 to 100 signatures apiece to make sure that they're all individual? That's a lot of bureaucracy, is it not?
I agree with you, and that's why I'm saying it should be, you can only sign once. So if you get 100 people who sign one another's documents, that doesn't fly anymore with the recommendations I've made.
Okay, so there's a bunch in there. Very interesting that one of the assertions that I made was that the longest ballot committee was acting like a political party. That seems to really be sticking in these questions and throughout the ethos that is going on in committee in this investigation. So very, very interesting to hear that. Also, that Mr. Calkins brought up the court challenge from Kieran Shukevich back in 2017. As we know, he brought this challenge trying to say, well, I was trying to run against Stephen Harper, but he showed up, per his own admission, with the $1,000 bond, but he didn't have, I believe, the witness to the signatures, and he didn't have all the requirements. And then that led to his court challenge trying to remove the $1,000 bond, the 100 signature requirement, and the witness requirement. So he's basically, I guess he was arguing that anyone should just be able to show up on election day and say, I'm running, with no requirement whatsoever. And Calkins is right. In that ruling, the judge had put in a ruling that the applicant had said that, well, they recognize that the $1,000 bond was meant to run frivolous candidates, but then goes on to say, well, but for affluent people, for people with lots of money, that's not going to prevent them from running frivolous candidates. Well, evidently it does, because they didn't run frivolous candidates before, and people with money aren't really in the habit of throwing their money away. To run the Battle River Crowfoot by-election prior to these rules, they would have had to pay over $200,000 as the longest ballot committee. That's not happening. I submit to you that none of the candidates would be paying $1,000 just to run with their name on a ballot in this protest. Wouldn't have happened. So I completely take Calkins' point on that, and Kingsley in his response says, well, I think 1,000 is too much, maybe in the hundreds of dollars. I think it should be something, as long as it isn't going to be determined to be a charter breach. But it was nice to see Kingsley come back and say, I think that electors should only be able to sign one nomination form. I think that's fair.
Given I believe that it was a travesty of the election. The longest ballot committee's actions made a mockery of our election process. Does the election law need to be changed so that people can actually? I asked the question of Mr. Thomas Shukevich when he was here if he'd been reprimanded, charged, or faced anything like that. Should there be some provisions in the law for those who make a mockery of our electoral system?
Very short answer.
Yes, there should be. And the Commissioner of Canada Elections should determine whether it's a compliance agreement, a fine, or prosecution before the courts. And I will say one thing, if it is a candidate, whether elected or not, that willfully participated in this, I think the solution should be in a court of law before a judge in Canada.
Okay, folks. Former Chief Electoral Officer Jean-Pierre Kingsley is saying that if you're a candidate, if you're affiliated with this, and you willfully participate in it, you should be prosecuted. I think a lot of people have been saying that. And I think a lot of people have been saying that in contrast to the fact that peaceful protesters were prosecuted for mischief, non-violent, and it was argued by the courts or by the prosecution that they disrupted the city of Ottawa. Okay, so if you disrupted one city, you're prosecuted. What happens if you disrupt an entire riding? What happens then? And I think these are the points that people are bringing up. And what Kingsley is saying is they should be prosecuted. So for all the people who think this is a joke, are you laughing now? Because this could be the consequences. And you have a former chief electoral officer saying that this should be the consequences. Because you're knowingly trying to disrupt this. And back to his original point, you are knowingly trying to undermine the legitimacy of both the election and the government itself. Sounds like mischief to me.
Just to follow up on that, an example was given to committee by Ryan Davies from the Northern Perspective. I don't know if you watched that testimony, where they had photographic evidence that had been posted by Longest Ballot Committee members on social media accounts of pages of signatures that did not have a candidate's name at the top of the sheets when the signatures were being collected. Northern Perspective says they submitted that to Elections Canada for review, and Elections Canada said that they had no evidence that any claim or request for a review had been submitted. So I'm just curious to know the mechanism behind the scenes at Elections Canada about how a question mark around signatures would be investigated and could be either legitimized or not if there's a concern.
Well, the Chief Electoral Officer has the option of referring matters to the Commissioner if he finds that something is amiss in the process. If it becomes to the stage where remedial action cannot be undertaken to his or her satisfaction, and this is how the accounts of members of Parliament and of candidates are reviewed. They're reviewed by Elections Canada. Difficulties are reviewed and solved between the candidate and Elections Canada. And where they cannot, they're referred to the Commissioner. That's how that refers to. And there were, when I was there was about, if I remember, a couple of hundred references made at every election because it could not be resolved.
So that's a very important piece of testimony. While initially sounding irrelevant and bureaucratic, it's actually really important. So we did submit an email, and we showed that on previous videos, with the evidence that we had up to July 25th of 2025, and we submitted that to Elections Canada and clearly laid it all out. Now, why Kingsley's testimony is important is because he's outlining this is the process that something like this would have to go through. The Chief Electoral Officer should be reviewing any complaints, should be determining if something is amiss, and if so, he should be passing that on to the Commissioner. Why is that important? Because, ladies and gentlemen, today, and today being October the 23rd, the Chief Electoral Officer is going to be appearing at Proc again. And no doubt, he's going to be asked follow-ups to this testimony. Okay, so Northern Perspective submitted this on July 25th, laid this all out. They've said that they've received no response. Why is that, Chief Electoral Officer? Did you review it? Did you pass it on to the commissioner? Is this under review? What's going on? We've heard from a previous Chief Electoral Officer that this is the process. Are you trying to say that you didn't follow the process? And this is where things start to get difficult. So, we don't have the answer to that question yet, but we're going to be getting it later today. And if you're interested in watching that, that will be available on Parleview. But we are also going to be having our own live stream coverage of this at 9 p.m. Eastern Time tonight. So you can join there. And if you haven't joined our committee live streams, they're very educational. We break everything down as it happens. You learn how committees work. You learn more government terminology, and allows you to have more sophisticated conversations and better arguments with people over these types of issues. And then it allows you to watch committee on your own. And you don't need us, because now you understand how the process actually unfolds. But we will break down the strategy and the implications and our take on what's going on in committee as they continue to investigate the longest ballot. And this will, by everything that we've heard in committee up to date, this will lead to legislative changes in the Elections Act. So for a lot of people that maybe say petitions don't do any good, this is proof that they absolutely do. Because our petition and our evidence, we have really pushed hard on this, and Parliament's going to be doing something about it by all the accounts that we've heard. So, stay tuned for that. But for the people that have participated with the longest ballot in previous elections, I'd be getting really worried right now, because this is not a protest, as I've said. This is not a protest. This is not freedom of assembly. What this is making a mockery out of our process. You're subverting the Section 3 Charter rights of Canadians. And that shouldn't happen. You want to protest? Grab a sign, write some letters on it, and go stand in front of a Liberal constituency office, because, be honest with yourselves, those are the people that denied electoral reform in the first place.